With the Hunter Biden pardon, the atopic of the corruption and the lying leading up to it is obvious. They had a very long time to think about it, and they still have no explanation otherwise.
You have said repeatedly yourself since the election, the president has said for months, no pardon was coming. Could those statements now be seen as lies?
First of all, one of the things that the president always believes is to be truthful to the American people. That is something that he always truly believes. And if you see the end of his, I assume that you've read his statement, and you look at the end of that statement, and he actually says that in the first line in the last paragraph.
See, he truly believes in being truthful. And you can tell that he was truly truthful because he said he was truthful. So that settles it. Truly, of course. And that lie is just one in the sequence of them. Joe Biden said he had no knowledge of his son's business dealings. That wasn't true. Joe Biden said he had never met any of his son's business associates. That wasn't true. Now he gives the pardon he said he never would, because likewise, that wasn't true either. But beyond all the lying and the corruption, there actually are some very deep layers of history and law here. I heard Jonathan Turley say in response that this Hunter Biden pardon is totally unprecedented.
The language of this pardon is virtually unprecedented. He's literally pardoning his son for any crime that he may have committed during these years.
When the pardon itself was published on Sunday night, that very broad language was glaring. It excuses Hunter from any federal crime, known or unknown, that may have happened in the last decade plus, dating back to right around when he got that high-paying job at the Ukrainian energy company Burisma, for which he had no qualifications other than his last name. Seemed pretty strange to pardon for undefined crimes, but hey, what do I know? I'm not a pardon historian, so maybe this is more common than I realize. Jonathan Turley is a scholar of these things, though, so if he says this is something of a never-before event, well, then there's got to be something more to it. And if this is historically unprecedented, that fact raises another question. Are there legal limits on presidential pardon power? And I know it's tempting to say automatically no, or at least very few. After all, the Constitution's pardon language on its face is very brief and broad, with little explicit limitation. I'm not saying Biden's pardon for Hunter is certainly illegal. I'm saying the argument that it isn't valid is more credible and interesting than I thought it would be. More on that in a moment. So how is this Hunter pardon historically unprecedented? Well, first, it's who was pardoned. The son of the president. Yes, relatives and even close relatives of the president have been pardoned before, but never a child like this case. George H.W. Bush did offer some sort of clemency to his son Neil for a financial scandal, but clemency is not technically the same as a pardon, and that was a non-criminal matter anyway. But in general, it's so unusual that in 2020, Chuck Schumer warned that Trump would do this for his kids and said it would be an abuse of presidential pardon power.
The president's reportedly asking his staff whether he can issue preemptive pardons for himself, his family members, Rudy Giuliani. There's a simple answer. No. No, Mr. President, that would be a gross abuse of the presidential pardon authority.
And then there's the length of time. Offenses within a nearly 11-year window. Pardons are typically issued for a specific crime or at least with reference to a specific event. This pardon is so broad, it's for any action in any event for over a decade's time. And that's the key distinction for this assessment. The fact that the pardoned crime has no definition, it could be anything from trespass to blowing up an entire federal agency and peeing on the ashes of the daycare inside. According to the Justice Department itself, such a non-specific pardon is highly unusual. A near zero is another way to put it. Pardons themselves are not rare, of course. There are tens of thousands of them in history. Many presidents issued thousands just themselves. But how many of those thousands of pardons were for unspecified crimes in this way? Well, according to one academic analysis accounting for 1974 through 2018, just 0.3%, only 7 out of nearly 2,200. And those 7 were really only 2 separate cases. On his way out of office in 1992, George H.W. Bush pardoned 6 men involved in the Iran-Contra affair, 4 already convicted and 2 charged but yet to go to trial. The other was Gerald Ford's pardon for Richard Nixon in 1974. Both of these cases are similar to Hunter's pardon, but still not as broad as his in time or unlimited coverage for crimes. The Iran-Contra pardons were for matters related to the investigation of special counsel Lawrence Walsh, who himself had defined boundaries on his jurisdiction. The pardon for Nixon was for unspecified crimes like Hunter's, but even that was for a smaller window in time, 1969 through 1974, about half the span of Hunter's pardon. All right, well, just because it's historically unusual doesn't necessarily mean there's anything legally wrong with it. Well, that's where things get interesting. And no, not because I say so or because my personal politics prefer it, but according to legal scholars and, of course, journalists who warned that Trump would do this 4 years ago and made the argument that such a thing wouldn't just be historically unusual, it may actually be illegal, beyond the bounds of presidential pardon power. Back in late 2020, Philip Bump over at the Washington Post published a piece titled "How Much Protection Can Trump Offer His Family with His Pardon Power?" A lot. The title, of course, implies that this is all legally square, but the substance of the story considers a credible argument otherwise. The piece quotes a law professor named Aaron Rappaport, who had recently published an analysis in the Connecticut Law Review titled "An Unappreciated Constraint on the President's Pardon Power." This piece likewise ironically framing the issue as something Trump would do. Rappaport's argument starts with a simple premise. The presidential pardon power is not unlimited by its own constitutional language and by judicial review. Of course, the constitutional language itself excludes impeachment proceedings, and the clause also specifies that pardon power only covers crimes against the United States, as in federal crimes only. The president can't excuse state charges. Those qualifications are explicit in the text, but there are implicit limitations that the Supreme Court has recognized too. For example, a president can't pardon future crimes. And for a pardon to be valid, the pardoned person must accept it, which they may not always do because it can be perceived as an admission of guilt or because it waives Fifth Amendment rights against self-incrimination. So if there are non-textual limitations on the pardon power, what is the source of those limitations? And to this argument's credibility, it's not just some make-it-up-as-you-go standard to get your political enemies. It actually is an originalist argument, as in, what did the framers intend? How was the pardon power understood at the time of the constitutional drafting and ratification? What is the history and the tradition? It's the same sort of analysis the Supreme Court uses to address any question that isn't explicit in the text. Rappaport first considers the debates at the Constitutional Convention and the Federalist Papers, but there are few mentions in either. The one consideration in the Federalist Papers is about who should have the pardon power, but not the scope of it. So Rappaport goes where the Supreme Court often goes, to English tradition and to English common law, on which much of the constitutional thinking is based. And there, we do find a lot of evidence for what he calls a specificity requirement for a valid pardon, as in, a valid pardon must define the specific crimes it covers. It can't just be anything and everything, as Hunter's pardon is. In 1389, Parliament passed the Pardon Act to restrict the king's pardon power and required the pardoned crime to be specified. William Blackstone, who wrote the best-known description of the doctrines of English common law, Commentaries on the Laws of England, wrote clearly in that work, paraphrased, "A valid pardon must name the particular offense to be pardoned." Blackstone's Commentaries was strongly influential and directly cited as authoritative on common law tradition by the framers themselves, and is often referenced by the Supreme Court on these questions through today. In fact, Blackstone has been previously referenced by the Supreme Court in addressing pardon questions specifically. There are other English legal analysts from the founding era as well. William Hawkins, in Pleas of the Crown, wrote likewise, paraphrased, "A valid pardon must specify the crime that is being pardoned." And Rappaport makes a broad historical argument beyond the specifics. If history is anything other than a specificity requirement for a valid pardon, then why is the entire history of the pardon in the English tradition to specify the crime? And why is the American application of it also to specify the crime? With only extremely rare exception. Now, I'm not saying that Rappaport's argument is absolutely correct. I've read about this for only a few hours myself, not a lifetime, and the Washington Post piece I first read also references legal scholars who say otherwise. Nope, the presidential pardon power does not require the mention of a specific crime. If that's what the framers wanted, they could have put that in there, but they did not. The point is this question: does the pardon power require specificity about the crime or not? That question has never been addressed by the Supreme Court. It remains open. The same sort of non-specific pardon did happen for Richard Nixon too, of course, but the validity of that pardon was never actually reviewed. The Watergate special counsel Leon Jaworski reportedly considered such a challenge, but it never happened. Nixon was pardoned and everybody just went home. And that ambiguity raises even more legal questions. How would such a challenge even proceed anyway? The special counsel's office in the Hunter Biden case, David Weiss, those prosecutors are also unhappy with this outcome, as one would expect. They asked the judge in the tax evasion case in California to close the docket but not dismiss the charges, and said the grand jury's decision to bring those charges should not just be wiped away, however that's handled procedurally. On Tuesday, the judge in the gun case dismissed it against prosecutors' opposition for the same reason. So could the special counsel's office bring a pardon challenge? I'm not sure who else even has standing legally. In the prior pardon cases before the Supreme Court, U.S. v. Wilson in 1833 and Burdick v. U.S. in 1915, the pardoned person refused to accept the pardon, so it makes sense that they would challenge. In this case, I guess theoretically prosecutors could challenge, but why would a president who just issued a pardon allow them to do that? Technically, the special counsel's office is supposed to have legal protection from firing, but the special counsel's office is still a part of the executive branch, and the head of the executive branch is not just going to let them undermine him in that way, unless a new executive takes control very soon. Another way things potentially get very interesting. But in the general sense, all of this turns into a fascinating area of constitutional law. On the one hand, the plain text of the pardon clause seems to give the president broad pardon power limited by only two things: federal crimes only and no getting out of impeachments. But on the other hand, if nobody can actually challenge that pardon power in court because those who could are under the president's authority, we now have an area of government power that exists outside of judicial review. And there is no such unchecked power otherwise, at least by constitutional design. So what is the truth of the matter? Well, just like why a Ukrainian energy company would hire a guy and pay him loads of money for no relevant experience other than bringing the best hookers and blow to the board meeting, the world may never know. But hey, if we ever do get the challenge to the Supreme Court, we'll get the answer to another pressing question too. Who really does throw the craziest party, Hunter Biden or Brett Kavanaugh? Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below, and especially over on X. That is at ML Christiansen. You're always welcome to coming out and chat in my live streams. Those are live on Wednesday and Sunday nights. Looking forward to it. Goodbye.